If you're arrested, we've previously talked about your right to a trial by jury. There are also several alternatives here in South Carolina that are alternatives that are up to you. They are your choices, which you can exercise in certain circumstances if you so choose, with the advice and guidance of your attorney. The first being is there is a veterans court. This court is confined for veterans of military service. There are certain qualifications. It must be what's called a high court case. They normally do not get involved in the magistrate's court. But if you're a veteran and you may meet certain criteria, the veterans court is specifically set up for you. It is a very generous type of thing. It is a program which you voluntarily go into. You have to comply with the rules. But when it's over, it will save you the fear of having to possibly go to jail, be on probation, and have an extensive criminal record. It is there for your benefit. If you're a veteran, please make sure that your lawyer is aware of Veterans Court and exercise that option if it is appropriate for you. There are other options, one being PTI, or pretrial intervention. That is a program for what is commonly referred to as first-time offenders. It is not for violent crimes. If you have a violent criminal history or you're charged with a violent crime, PTI will normally not take you. The PTI program is a program in which you again voluntarily participate. You will normally have to do a certain number of community hours service or community public service. You will also be required to go to meetings or counseling, and at the conclusion of that, if you successfully complete that program, your charges will be dismissed. In essence, you will have no criminal record. The PTI program is greatly misunderstood because most people think it is for first-time offenders. The law in South Carolina provides that the PTI program is available for those who do not have significant criminal records. There is also what's called the conditional discharge. Now, that only fits for certain crimes. An example would be simple possession of marijuana. And what that provides is you are pleading guilty, but if you don't commit any more offenses or don't get in trouble in a 6-month period of time, then those charges will ultimately be dismissed. There are also, for young people, there's something called the Youthful Offenders Program, what's also called a YOA sentence. That is not eligible for anybody over the age of 25. Normally you will be sent to Gibbons Youth Center, which in my generation would be called reform school, but it's certainly a better thing than prison. It is not quite as harsh, and it will help young people get through the program. But again, the age limit's at age 25, and that sentence is an indeterminate sentence not to exceed 6 years. Normally it can be done in 9 months.